Welcome to the What Matters Today podcast from the Geneva Graduate Institute. I'm Dan Graham, Head of Communications at the Institute. In this podcast series, we ask members of our faculty to comment on key global issues. The recent U.S. attack on Venezuela and the capture of President Nicolás Maduro have sent shockwaves across the global stage. For many observers, the operation represents a clear breach of international law, raising fundamental questions about state sovereignty, the use of force, and the immunity traditionally granted to sitting heads of state. So what does this mean for international law, for global stability, and for the future credibility of multilateral institutions? That's what we'll explore in today's episode. My guest is Professor Nico Krisch, Professor of International Law and Head of the International Law Department here at the Geneva Graduate Institute. So Nico, welcome back to What Matters Today. It's always great having you on this show. The American attack on Venezuela and the capture of its president are considered by many observers to be an illegal act of aggression and a clear violation of the United Nations Charter. Can you help us understand this view, especially with respect to the principles of sovereignty, territorial integrity, and political independence of states?
Sure, and thanks, Dan, for having me here on this podcast. So, somehow, of course, most international lawyers have been somewhat shocked by the intervention in Venezuela. Though, of course, for a long time, it was entirely normal to take other countries, intervene in other countries, right? In 19th century practice, people wouldn't have been surprised by gunboat diplomacy and territorial conquest. And that was widely seen as legal at the time because there were no real constraints on the use of force. In parts, there were maybe discussions about that, but in principle, it was seen as a normal thing to fight disputes out by force. Now that changed, of course, in the early 20th century with the Briand-Kellogg Pact in 1928, and then with the UN Charter. The international community has established pretty strong rules prohibiting the use of force between countries, outlawing war as a tool of policy. And this has held surprisingly well, you can say, over the following decades after the adoption of the UN Charter, has matured into customary international law. Of course, there have been violations throughout, no doubt, but somehow the idea of the prohibition on the use of force as a principle was upheld. And Article 2.4 of the Charter, which is really the core provision here, stipulates that all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state. Lawyers interpret this really as saying, well, you cannot use force against any other country. That's been confirmed many, many times over. So even if there was what the US was doing now may have been lawful in the 19th century, it's clearly not lawful today, and there's a very widespread consensus. I don't see anybody reasonably defending the action on legal terms. And remarkably, the US government even isn't really defending the action on legal terms. Mostly what they're saying, well, that's a law enforcement operation, a sense of domestic law paradigm. You could say, well, we have to implement our domestic law, but they don't talk about international law. If they did so, they would have to talk about the potential exceptions from the provision on the use of force, self-defense, which somehow came out, but very vaguely, and talk about a threat from drugs or from immigration, right? It's the vague threats that are invoked that clearly don't rise to the threshold that you would normally have for an armed attack that you need in order to trigger the right to self-defense of a state. So, and we don't really have even much of an effort to justify things on international law terms here. And clearly, the later references then, to the stolen oil, that are maybe the clearest remnant of gunboat diplomacy of the 19th century. They're clearly also not a basis whatsoever for somehow intervening in another country. So in a sense, it's clear the community of international lawyers is united in condemning what has happened, as calling it out as an unlawful use of force. But the sad fact is that it doesn't really seem to matter.
And under international law, sitting heads of state usually benefit from immunity against prosecution abroad. In this case, has that principle been breached? And if so, what could that mean for the legal validity and proceedings against Nicolás Maduro?
Yeah, so it's clearly been breached. So immunity from any legal action, right, civil or criminal, is the core of the provision that has been customarily accepted in international law for heads of state, heads of government, and also foreign ministers. In fact, the International Court of Justice 20 years ago in the arrest warrant case, which involved Belgium and the Democratic Republic of the Congo, kind of upheld that and specified very clearly that, in that case, a foreign minister, but that applied likewise to the head of state, enjoys inviolability from suits in other countries. And the US itself has also, in comments in discussions in the International Law Commission on the project of the International Law Commission to do with immunities, has itself emphasized that this is their understanding of the customary rules in place. So that's been clearly breached, right? You put another president of another country to trial, you breach it. Now, the one justification that the US seems to be wanting to use is that they think that Maduro is not a legitimate head of state because the elections were rigged or electoral fraud and the like. But that is not normally accepted at all as a justification of any kind. What matters under international law is that somebody is in fact exercising the office of the president and representing the country. Otherwise, all countries could sit in judgment over who they would like to be the president of another country. Now, is this going to matter for the criminal proceedings against Nicolás Maduro in the US? That's a different story. That has partly to do with the fact that, of course, international law and US law are not the same thing. Right. And the United States doesn't immediately apply international legal rules in their own legal system, like many other countries also don't. There's a precedent of the US Supreme Court of about 30 years ago, kind of in US v. Avadat Machain, where the US agents had unlawfully abducted an individual in Mexico and brought them to the US to stand trial. And the Supreme Court found that the unlawful abduction in the first place that violated international law was not a bar to criminal proceedings in the US. So if this same principle is applied here, it might not matter for US courts whether indeed the seizure of Nicolás Maduro was unlawful under international law in the first place.
You hinted at this before, like the reactions of others. The European governments have reacted rather cautiously to this. How do you read that response, and what kind of precedent could it set for future crises?
Well, it's really one of the most worrying aspects, I find. Well, there are lots of worrying aspects about this topic, but clearly the responses of European governments have been particularly concerning because they've been really evasive for the most part, right? Calling for calm, for peaceful transition of power in Venezuela, not really calling out violations of international law or protesting directly, instead emphasizing also, in fact, the illegitimacy of the Maduro government, in a similar vein as the US has done. And we've seen this in the EU Commission, we've seen this in Germany, and the UK, also the French president. So a really widespread, very muted response, very in contrast with other governments. Many others have protested, Latin Americans especially. There's been a joint statement by a number of countries, Brazil, Chile, Colombia, Mexico, Uruguay, and including Spain, that directly challenged the legality and rejected the unilateral intervention of the US. Of course, we've seen the same from the Chinese government, the Russian government, many other governments, South African government, also in the UN Security Council. So there's a clear contrast there. And that contrast, of course, reinforces the view of many in the international community that Europeans apply absolutely double standards when they talk about international law. That was already strong after Gaza. But it's become even stronger now. Since you point to violations when it's your enemies that commit them, but you don't do it when it's your friends. And of course, that doesn't go down well. And many countries had already been hesitant to support the condemnation of Russia for its invasion in Ukraine, where Europeans and Americans managed to get together a large majority in the General Assembly for condemnation, 141 states at the time. But many had doubts on whether they should get onto the bandwagon, and quite a few countries stayed off. Now, I think after Gaza and after Venezuela and all kinds of other things, many countries would think twice before supporting a European proposal to condemn this or that violation of international law just because there's a strong delegitimizing effect, really.
Right. Donald Trump has made no secret of his desire to exert control over Venezuela, and there are concerns he could pursue similar strategies in Colombia, Mexico, Cuba, and not to mention his ambitions regarding Greenland. From an international law perspective, how should we understand this approach to reshaping spheres of influence?
Yeah, so it takes us really into a pretty different order than the one that we had imagined. So clearly it's one of spheres of influence, great powers. It harks back in some ways to the Monroe Doctrine, right? An early 19th century doctrine in which the US stipulated that it would come to the aid of Latin American countries against European interventions. That was initially greeted by quite a few of the newly independent Latin American states, but once the US used that to intervene even against the wishes of Latin American countries, especially after Theodore Roosevelt's broadening of the Monroe Doctrine, of course, many of them were very wary of the imperialist undertones of it. But clearly, since we see kind of a reemergence of similar thinking, from a standpoint of current international law, this is, insofar as it implies the use of force or intervention into the internal affairs of other countries, this is unlawful, also insofar as it touches upon the permanent sovereignty over natural resources that countries enjoy. So all of this is clearly violated if you make another country subject to your own wishes and policies, as the US is now trying to do. Also, especially if there's a continued threat of force, that if Venezuela does not follow the line of the US government, well, there are going to be more helicopters and warships and the like. So it's a clear threat of force, and even the threat of force is prohibited by the UN Charter. So it's a continued violation of Article 2.4 of the Charter. So clearly, if that was sort of more generalizable, we would clearly see a departure from that idea of an international law that protects the sovereignty of individual states in favor of a system that protects the prerogatives of great powers. If that were somewhat legally accepted, right? Clearly, that's not a claim currently, but it's something that may happen de facto rather than de jure over time.
And for my final question, beyond the legal questions, this U.S. operation has clearly sent shockwaves through the international system. We're now seeing other major powers talk openly about intervening in what they consider their own backyards, including China and Russia. What impact could this case have on global stability and on the credibility and effectiveness of multilateral institutions?
Yeah, so I think the impact is potentially very grave, right? On the one hand, an impact on norms and institutions, right? So as I mentioned before, the US doesn't even bother to justify the intervention as a matter of international law anymore. Donald Trump, when asked in a recent New York Times interview whether the US needs to abide by international law, he said, well, I do think that it should abide, but it depends what your definition of international law is. But the answer is I do, but we have to keep the United States safe, and we have to keep parts of the world safe that we feel responsible for. So essentially that's a message. If the US sees a threat of whatever kind, drugs, immigration, what have you, it can break international law, or it can redefine it in this approach. And of course, it's pretty similar to others. We've seen this with the Russian interventions in Georgia, in Ukraine, with its threat against the Baltic states, justified on the basis of a threat coming from NATO, or threats to Russian speakers in those countries. We've seen similar rationales in the Israeli action on Iran, Yemen, and Qatar, where since it acted on the basis of threats and not directly justified on the basis of self-defense or imminent attacks. And to an extent, of course, we see this with China and the South China Sea. Spheres of influence become a kind of more dominant logic. But that means there's a risk of a continued erosion of international law as a standard. Sometimes it is used in lip service, but in other times it is not even invoked much anymore. The UN, of course, is sidelined in this logic because the dominant logic is one in which a powerful country establishes a sphere of influence, of territorial influence around it. And it's a word of might rather than right. So clearly that's a threat. And the extended threat from that, of course, means that since there's no predictability anymore in international relations, that the countries cannot rely on the fact that there's something they can work with, that can predict kind of is stable over time, everybody has to make sure their own survival is assured. And of course, that drives us much deeper into a security dilemma, as many political scientists have long described, that becomes much more acute once some fundamental norms are no longer respected. Now, of course, one shouldn't overemphasize the degree to which international law and multilateral institutions have mattered in the past. Maybe they've mattered more, but of course they depend largely on the acceptance of states, on the readiness of states to live by international norms, to follow international institutions, because these institutions and these laws don't have independent enforcers. And that, of course, has long been under challenge. International law has never lived an easy life, not at the beginning of the 20th century, not during the Cold War, and certainly not now. So challenges come in waves, but clearly kind of the hope that one would have achieved a more stable international order with rules that are commonly accepted by all is dissipating. And that means, of course, countries themselves are thrown back into the need to procure their security for themselves, which will drive them to invest more into defense spending.
Right.
And of course, often, as we know, kind of that leads to self-fulfilling prophecies of countries in situations of instability starting to wage wars and engage in conflicts with others because they feel under threat, or they feel that there's a possibility of strengthening their position beyond what it is so far. So it's not a happy world. Whether we get there or not, I think will depend to a large extent on the reactions of other countries. And that's why I said the lukewarm reactions of European countries worried me particularly. So if we want to uphold an order in which norms matter, common standards matter, predictability is ensured, it depends on countries coming together, so really forging an alliance around those kinds of norms and saying, well, we're going to stand up and call out violations, but also support each other in the defense against such violations. And that's somehow, I think there's movement among countries to stand up, because there's clearly, for most countries, this is a major threat. Whether this is going to be strong enough to withstand those forces that pull us away from the system is another question. But clearly there's much dynamism, and I would hope that European governments too would come to the realization that it depends on them to defend those kinds of rules. And otherwise, you mentioned Greenland, right? Sort of the moment Greenland is attacked, or Latvia is attacked by Russia, they may not have many friends defending the rules that they need and that they invoke against those that break them.
Nico, thank you very much for helping unpack this extremely complex and fluid situation. Thank you.
Thank you so much. It was a pleasure.
This podcast series is produced by the Geneva Graduate Institute Communications team. For more information about the Institute, please visit our website at graduateinstitute.ch. I'm Dan Graham. Thanks for listening.